between male and female plants, their potency, and so on. So, Your Lordship, that is an area that we are reserving for the main trial. We'll deal with those issues at that point.
Yes.
In addition to that, Your Lordship, the defendants submit that for purposes of the striking out application, those submissions by the plaintiff should be disregarded because they have no place in these proceedings. They were premature. Further to that, Your Lordship, the plaintiffs spoke about the so-called mischaracterization of this matter by the defendants. Your Lordship will know from the pleadings that we take issue with that. One of the reasons being that in those same particulars of claim at paragraph 10.6, Your Lordship,
Paragraph?
10.6, Your Lordship, of the amended particulars of claim, the plaintiffs challenge, and I quote, the constitutionality of criminal prohibition of cannabis as provided for in sections 4B, 5B, and Part 3 of Schedule 2 of the Drugs and Drugs Trafficking Act of 1992, on the basis set out in the subparagraphs that run from 10.6.1 to 10.6.4. I don't need to go into those, Your Lordship, because those are precisely the matters that go to the constitutional issues that are raised that we will be dealing with on the merits. All I wanted to point out to the court is that the plaintiffs seem to be prevaricating between whether they want adults only, who they don't define, to be permitted to use, possess, deal in cannabis, or whether they want all and sundry in terms of 10.6. Your Lordship, I leave that matter there because we will be delving into it later. Then there were matters, Your Lordship, where the parties actually make common cause. By way of example, the issue that there are experts who agree that further research and further study into the harmful effects, etc., of cannabis needs to continue to be undertaken. We make common cause with that, Your Lordship, but again, that's an area we will deal with adequately, I believe, at the time that we are cross-examining the relevant witnesses.
Yes.
So that goes to what I have identified, Your Lordship, as the issues that deal with the merits that we really do not want to traverse in this application. Your Lordship, that then takes me back to the beginning, where this court was told that this application is vexatious, completely unnecessary, and a couple of other choice words. We were also told that it's prejudicial to the interests of the plaintiffs and so on. Your Lordship, this theme that was adopted by the plaintiffs runs through just about everything they submitted to this court yesterday in answer. And it really misconstrues the purpose of a striking out application. And I would like to submit, Your Lordship, that in the manner in which the plaintiffs approach the striking out application, they seem to insist on putting form over substance. They gloss over the substantive issues we're raising and seem to want this court to adopt the attitude that the rules are there because they are rules. Your Lordship, there's authority. I think it's Brown versus Boyce. It's a decision that says essentially that the rules are there not to hamper the court, but to promote the administration of justice. And this is precisely why in this constitutional dispensation of ours, Your Lordship, we now have a provision in the Constitution that speaks to appropriate, just, and equitable relief. Because courts often have to look at the rules and adapt them in a manner that actually promotes justice, equity, public interest. This is what a constitutional democracy is about, Your Lordship. And the rules must fit into that. The courts are alive to that. And the courts have in fact been doing exactly that. If I'm not wrong, Your Lordship, my learned colleague, in fact, yesterday did say that the DJP, in calling the parties in for the case management process, himself was adapting the rules. The whole case management process is an adaptation of the rules. The pre-trials that are presided over by judges, that has been an adaptation of the rules. So, Your Lordship, the context I put to this particular application that we have launched is that form should not be elevated over substance. The second theme that the plaintiffs promoted yesterday, Your Lordship, was that the orders sought in the notice of motion were overbroad. In particular, they really are speaking to prayer 2, Your Lordship, of the notice of motion, which speaks to the articles, the journals, being found to be irrelevant, and for that reason, struck out. Now, Your Lordship is quite alive to the fact that there is a founding affidavit that accompanied that notice of motion. In the founding affidavit, Your Lordship, we had categories of concerns, three categories that the defendants said they were concerned about because the documents that fell into those particular, and this is really important, Your Lordship, because they completely misrepresented our approach. We had categories, Your Lordship, where you had documents of a particular genre that we said were irrelevant, of a different type that we said were totally superfluous, and yet of a different type that we said showed no nexus at all. The importance of those categories, Your Lordship, to the prayers sought, is that this court is well aware that it also has the powers, its inherent powers it has, to consider further and alternative relief. And further and alternative relief, Your Lordship, means exactly that. You might ask for A, but you will get B, this is what the judge essentially would decide. Having considered what you have placed before this court, where I understand you've asked for B, I don't think you've asked for A, I don't think A is merited today, because sound reasoning, you will get B. That's further and alternative relief, Your Lordship. So this court might just be minded to say, yes, there is a category of documents, and we'd like to persuade the court on this. I will be going back to it a little later. That speaks to matters that a different branch of government is currently working on. There are judgments of the Constitutional Court and the SCA that say the judiciary, the courts, will only intervene in another area of competence that's under the control of a different branch of government if the Constitution mandates it to do so. It's actually important, Your Lordship. This court cannot mirror more to decide to legislate. This court cannot mirror more to, that's obvious. Second point, this court cannot mirror more to decide to take work away from the legislature and decide it's going to do it itself or decide to allocate it elsewhere. I have understood that what the plaintiffs appear to be asking for at the end of the day, Your Lordship, is a declaration of unconstitutionality. And further to that, they ask that these matters be sent to Parliament for Parliament to regulate the possession and dealing in. Our submission on that aspect, Your Lordship, is quite simple. That process is in place. It's ongoing. Oh, Your Lordship, I must say I appreciate you not interrupting me. Thank you.
Were you expecting me to?
Yesterday was a different day. It helps. It does help.
But also, if I have some issue that needs clarification, I need to interrupt.
But of course, Your Lordship.
I try not to.
The third theme, Your Lordship, presents a response to the submission that was made yesterday, that the defendants are completely wrong when they question the summaries.
The plaintiffs.
No, the plaintiffs made the submission that
Oh,
the defendants, the plaintiffs made the submission yesterday that the defendants are completely wrong when they make the submission that the summaries are inadequate. The summaries of their experts are irrelevant. The simple point that we made in relation to that aspect, Your Lordship, is this. Those summaries are intended to assist the court. It's as simple as that. The expert isn't talking to himself. He's assisting the court because this expert is supposed to have specialist skills that the court doesn't have. The expert doesn't come here and try and interpret contracts or legal documents. That's the court's function. But there are factual technical issues that the expert will come to this court to explain to the court, break down into simpler terms. And Your Lordship, in circumstances where this court is asked in a pre-trial, in a practice note, not to read the annexures to those summaries because it is not necessary. Those summaries had better be completely comprehensive so that the judge, in fact, does not have to read all the bundles of documents that supposedly speak to this expert summary. And it is for that reason, Your Lordship, that we say it is very critical for those summaries to be comprehensive, to underpin the propositions that are made, to set out the reasoning, to draw conclusions, but to tie those in to the documents that they rely on. Then, of course, it may not be necessary
Now
for the
I'll
judge
have
to
to
read the
interrupt you,
papers. Oh,
Mr. Basha.
of course, Your Lordship.
You see, when you say that it must be comprehensive,
Yes, yes.
I have some difficulty with that proposition. For example, as I understand the sub-rule, and I can refer you to Harms on the commentary on the rules of court, and where the commentary is in relation to this issue about what is a summary. And he says the sub-rule should be restrictively construed, and that a summary should be no more than a brief synopsis. You're saying it should be comprehensive. Is that not the opposite of what is required?
Your Lordship, I believe if I change my language, I might be able to persuade the court that I do not believe we're saying different things. It must be content-laden. It must be the court must be able to understand the theses or the propositions,
All right,
the
that I
reasoning.
appreciate,
Yes.
yes.
It's not length, Your Lordship. It's not a dissertation we're asking for,
Oh.
but we're asking for language that the court will understand, because that's why they're here. But we're also asking for verifiable propositions, themes, logical reasoning. And the purpose of that, Your Lordship, is not only for the court to be able to understand what is being placed on record, but for the experts from the other side, from the opposing side, to be able to interrogate those where they disagree. And for the court, when the court asks questions at the end of the witnesses' evidence, to be able to ask relevant questions again, because the court has understood what is set out in the summaries. Your Lordship, our submission on that point is there will be instances where those summaries are irrelevant, where those summaries do not explain how that expert arrived at the conclusions that are drawn in the summary. In those instances, that particular expert has not given an opinion that's worth anything at all to the court. So there's no value. It becomes irrelevant, Your Lordship. And in those circumstances, the court may just have to read all of the annexures that supposedly inform that expert's concise, if I turn it around, summary. And that's the simple point we make, Your Lordship. A court can't abdicate its responsibility to understand all the evidence that's placed before it. But there's nothing wrong with a court asking for assistance using the tool of expert opinions from experts to assist it. It's the norm. We know that, Your Lordship. I was simply going to point, Your Lordship, to the Cooper's case, which I relied on quite heavily yesterday, because it says exactly what your Lordship was intimating as well, that really a summary is brief. It dispenses with needless detail. That's what a summary is. It's compendious. It goes on to say it's a brief account, an abridgment. Unlike an opinion they define as judgment or belief based on grounds short of proof. So your opinion, you set it out. You must explain how you arrived at the opinion as an opinion. They then define a formal statement, your Lordship. A formal statement by an expert is one, when consulted, of what he holds to be the fact. That's a formal statement. The important one, the reason I've gone through all of them, your Lordship, is because you then get to reason. Reason is a fact adduced or serving as argument, motive, cause, or justification. And they go on to say, your Lordship, in the context of which phrase, reason therefore, as used in Rule 36(9)(b), it means or at least includes the facts or the data on which the opinion is based. Your Lordship, there's a lot more on page 371 of Cooper's. I put some of that into the earlier heads that I submitted to your Lordship. I believe that is one of the more seminal cases on expert witnesses, as is the PwC case that I've again referred to in the heads that I'd given your Lordship.
Yes.
I would like to submit, your Lordship, that the court has regard to those views. The fourth theme, your Lordship, I've touched on, so I will not waste time on this. That's the Glenistic Doctors for Life. I gave you those particular references in my other heads, your Lordship. There are a number of others, and your Lordship, that speak to the same theme, that the courts will only intrude, is the word they use, in fact, your Lordship, into the domain of another arm or branch of government where the Constitution mandates it to do so.
That deals with the merits again.
Yes, which is why I'm saying I'm glossing over this. I think I'll put a full stop with that reminder from your Lordship. From that, I move on to the fifth theme, your Lordship. And these are themes that arose yesterday during the answer. The fifth theme traverses the expectations of the parties in respect of the manner in which the objections were raised by the defendants and the manner in which the plaintiffs responded to those. This theme, your Lordship, I'll deal with in a little more detail because it really speaks to the correspondence. I will not be taking the court through the correspondence. That was done yesterday, and the correspondence is on record. I will simply be speaking to the case management process. I know your Lordship presided over one of the meetings. I know the DJP presided over one of them, and the pre-trial process, and really what those are intended to achieve. And I will then tie that theme into, again, the further and alternative relief, just equitable relief, that I believe this court may be minded to grant. Sixth and last is the scope of the case pleaded by the plaintiffs. I've dealt with that, your Lordship. That will go to the merits. I should really say the seventh will be costs, which I will deal with, because yesterday this court was told that we have been so reckless, we have been so vexatious, that a punitive cost order ought to be imposed on us. I would like to deal with that submission, your Lordship. Your Lordship, one of the important areas maybe to just highlight is this. One of the questions that arose yesterday, both when I presented the defendant's case and in answer, was whether this application was indeed necessary.
Sorry, whether this...
It was necessary. Whether it was necessary at all. It's an important point, your Lordship, because I would like to place on record that this was a bona defied attempt by the defendants, despite the tensions between the defendants and the plaintiffs, to bring to the attention of the court the fact that we do not have to be here for 19 days. On reflection, we really do not have to be in this court for 90 days. The modality we believed we could adopt was that of a striking out application. And a striking out application, Your Lordship, because as Your Lordship would be aware, the last case management stroke pre-trial meeting with Your Lordship, in fact, was on the 20th of July. This matter was set down to run as of the 28th of July. So whichever way one looked at it, Your Lordship, 31st of July. So whichever way one looked at it, Your Lordship, thank you, we were sailing very close to time in relation to the notice period that is required of Rule 30A, should a striking out be brought.
Perhaps I should. I'm trying to understand the fact that you included the meeting in my chambers in the week, I think you said it was on the 20th of July.
Yes.
That was not a pre-trial meeting in that sense. It was simply to get the parties to come together and discuss various issues with regard to the trial, such as one of the issues I raised was about a running record, for example, and of course a number of issues then arose in the course of the discussion. But mine was, my meeting, or the purpose for calling the meeting that I did, was to ensure that when we start on the first day of trial, we know how it's going to go about. There was no application to strike off at this stage. The issue about live stream broadcasting was still a live issue. And that was also mentioned. Of course, then in the course of the meeting, it was mentioned that the defendants still have problems with the way in which the plaintiff's experts' summaries have been provided by including annexes.
Indeed, so, Your Lordship. I would then like to say it was more of a case management
Yes.
effort,
Yes.
not a pre-trial, because
That's right.
there is, Your
Yes.
Lordship is quite correct with respect. There is a difference between the two. Your Lordship, the reason that particular date and that particular meeting is rather important is because I'm instructed that the view of the defendants after that was it appeared to them that the plaintiffs were completely intransigent, that they would not be making an attempt to meet the defendants halfway. The defendants then responded, after that meeting, Your Lordship, to the plaintiff's 37-4 request, a Rule 37-4 request. Your Lordship, it was, I have the document, it's dated the 28th, which is last week, Friday, the 28th of July. It really was only, it was served on the 31st, Your Lordship, but issued here in court. The stamp reads the 2nd of August, which is yesterday. I am told that it has now been handed to Your Lordship, and I'd like to think it is in Your Lordship's file.
What is this document?
It is the... This is the... I do apologize, Your Lordship. Yes, but it should be... It is. I'm advised, Your Lordship, that it might have... I'll ascertain, Your Lordship,
But
whether it is in fact in the court file.
What is the document?
It is simply the defendant's response to the plaintiff's Rule 37-4 request. So 37-4 request.
And you said it was filed yesterday.
yesterday, Your Lordship.
Well, then
I'll ascertain that with the State Attorney
don't have it.
when he arrives, Your Lordship, and I'll advise your registrar on where exactly this document might be in the court file. It's a rather important document, Your Lordship, because the admissions made in this document are as follows. And I'd like to read it into the record. Paragraph 1 reads, the admissions sought by the plaintiffs in these paragraphs are in relation to the issues that are not relevant before this court, matters that are for expert evidence and argumentative material. Paragraph 1. Paragraph 2 reads, the 1st to 7th defendants wish to repeat, as previously indicated on various occasions, that they are highly prejudiced by the volume of articles and publications compiled by the plaintiffs and whose relevance to the issues before this court is unclear or unknown. Second paragraph, Your Lordship, the defendants have filed their expert reports and amended plea. Furthermore, like the plaintiffs, the 1st to 7th defendants also reserve their rights to file further expert reports should the necessity arise, particularly given the importance of the matter. Paragraph 3 reads, Your Lordship, the 1st to 7th defendants reiterate the necessity of the opposing experts to meet and attempt to compile a joint minute in order to assist the court and the parties to determine the nature and extent of the dispute before the court. Paragraph 4, Your Lordship, reads, as previously indicated, and given the prejudicial nature of some of the articles and publications contained in the plaintiff's papers, the 1st to 7th defendants reserve their rights to bring an application.
I'm sorry, I have to interrupt you at this moment. I'm not sure how long that is.
This is the last sentence, Your Lordship.
That's the last?
Absolutely.
Because I'm still a bit concerned of the relevance of this document in the striking of application when it has not even reached the court.
Your Lordship, but it reached the plaintiffs, this document. And the last sentence I was actually reading, Your Lordship, is, I'll just continue where I left off. The 1st to 7th defendants reserve their rights to bring an application for the striking out of the irrelevant articles and publications.
But the striking of application has been already launched before this. Am I right?
Your Lordship, they received this on the 31st.
Without having had it in for perusal, I'm not able to deal with it at this stage, but am I going to be provided with a copy of that?
Most certainly, Your Lordship. Can I hand, this one is not marked, Your Lordship. Might I hand this up?
You may
it
hand
has
it
the
up.
court stamp on it. And it is dated 2nd of August, Your Lordship, but the plaintiffs received it on the 31st of July.
Lord, if it might assist you, Lordship, that very document forms an annexure to the answering affidavit in the strikeout application. So it is in before the court, Lord. I'm not sure if it might assist you rather than taking new documents.
Your Lordship, I am simply referring now to those contents, and really the only
Well,
point...
if it has been annexed to the answering affidavit, then that's fine.
As the court pleases. The point essentially, Your Lordship, comes back to this question: was the application necessary or vexatious? And the submission I make, Your Lordship, in light of the correspondence, pre-trial discussions, the case management discussions, and the Rule 37.4 response of the defendants, is that at every point the plaintiffs were aware or made aware, one, that the objection of the defendants was a continuing objection, Second, Your Lordship, that the defendants had not waived their right to make application for this court to strike out material that really was not helpful to the court. And all of this has been done, Your Lordship, not only to assist the court, but to avoid having the plaintiff, I beg your pardon, to avoid having the defendant scratch around and try and guess what they have to read, what they have to prepare on, whether their experts are the correct experts, whether they don't want to be taken by surprise, essentially, Your Lordship. And the rule says the idea is don't take your opponent by surprise. The other consideration, of course, Your Lordship, is with the court appreciating that there are documents that are an issue, possibly reading some of those documents, even if it's at a thematic level, the court might want to give guidance so that we can concertina the length of this trial, Your Lordship, narrow the issues, and get down to business when we do in an expeditious and effective way, and get this trial over and done with, because it's the type of matter that is making its way up to the Constitutional Court, simply because the issues raised are constitutional matters, Your Lordship. Declaration of unconstitutionality has to go upstairs at some point. I've dealt with the question of whether Your Lordship would have to read the annexures. I would like to stand by those submissions and just again say context. In law, context is all important. And
Yes.
the context of what we're working with here, Your Lordship, it really depends. Where the summaries are the types of summaries that are informative and that assist the court, well and done. Where they are not, it really is the duty of an opponent to say, this is not going to assist the court, this is going to waste the court's time, this is going to waste everybody's time, and deal with it effectively one way or the other. I would like to add to that, Your Lordship, that as Your Lordship indicated yesterday, it may be that the more prudent time to interrogate those summaries and those annexures is during the trial. But I would like to believe, Your Lordship, that that doesn't mean that the court will always, under all circumstances, avoid striking out applications on the basis that the issues raised can be dealt with during trial. I would also, Your Lordship, just like to underscore the reason courts rely on experts. And there's a Supreme Court of Appeal decision, Your Lordship, that talks to the probative value of two particular experts who appeared before that court. It's the case of Michael and another versus Linksfield Park
Yes,
Clinic.
it's a well-known case, I'm aware of.
Aha. Your Lordship, if I might, just for purposes of emphasizing, say the following. It's a very short quote from that case. Talking to the eminence of the experts, the court said that, of course, it's no guarantee, your eminence as an expert, is no guarantee of the acceptability of their evidence, and although it does reflect the extent of their knowledge and experience, it is the quality of their reasoning that we consider places their evidence on a significantly higher plane than that of other experts. That's important, Your Lordship. Those summaries must reflect this thinking. And where they do not, in other words, the court gets no appreciable help, that's the Cooper PwC language, appreciable help from experts, then they really are not adding value. Their evidence will, or rather those opinions, are irrelevant, and they should be struck out. The last little extract I would like to bring to the court's attention, again, I'm sure authority of the court is very familiar with Holzhausen versus Ruet. I have mentioned it in the earlier heads I submitted, Your Lordship, where that court said that essentially, though a court may rely on expert opinion of a witness, and I quote, "The expertise of a witness should not be elevated to such heights that sight is lost of the court's own capabilities and responsibilities in drawing inferences."
And for the
from
court
it.
to be able to do that, it would have to hear the evidence in the course of the trial.
Precisely, Your Lordship.
Yes.
A court might have to go further and call for all those annexures. Again, I'm just tying up
Yes.
that mini theme with this. It depends. Context, Your Lordship, is everything. To the extent that this court would like me to deal with the rule under which this application is brought, Your Lordship, I go back to the essential sound bites that one, Rule 38 provides for this. We, of course, did not comply with the notice period. But our submission, Your Lordship, is that Rule 36(9)(b) confers a discretion on the court. And if I might quote from Erasmus, Your Lordship, just to keep things short, that discretion must be exercised judicially on a proper consideration of all the relevant circumstances. Relevant circumstances include A, the reasons for non-compliance with the rules, with the request or the notice concerned. We're dealing here with the notice, of course. And in this regard, whether the defaulting party has recklessly disregarded his obligations. I want to pause there, Your Lordship.
You concede that the defendants did not comply with the time period set out in Rule 30A.
Absolutely, Your Lordship.
Yes. Now, where there is a non-compliance with the rules, should there not be a condemnation application in which all these reasoning and so on would be set out?
Indeed, so, Your Lordship, there ought
That has
to-
not been done.
That has not been done, Your
Yes.
Lordship. But, Your Lordship, the point, I raised the point
And
under...
if I may interrupt you, because I'm sure you're aware that condemnation is not merely for the asking.
Absolutely. No, I can only agree, Your Lordship. Those are all tick, yes, yes. Those
Right
are
principles.
straightforward answers. Absolutely, Your Lordship. Your Lordship, again, I would make the submission, two submissions in that regard. If the court is so minded, the defendants have no difficulty in filing an application for condemnation.
No, it cannot be done at this stage.
Your Lordship, I say this only because there may be the possibility that this, even at this late stage, that this particular application is pended, suspended.
And remember, I'm simply raised this point on the basis that you say that the defendants rely on Rule 30A. Whether that is correct or not is something I would still have to determine, whether the defendants adopted the correct procedure. And of course, the eighth defendant says that they do it in terms of the Constitution.
And if my recollection serves me well, Your Lordship, I think I made the same submission yesterday, that it's brought in terms of the inherent powers of this court to regulate its own processes. The
Yes.
timing was out. But, of course, the rules do require an application for condemnation. Your Lordship, to go back to the factors that the court would consider, recklessness is a factor. The second one is whether the defaulting party's case appears to be hopeless. We would be the defaulting party in this instance, Your Lordship. And the submission I make is that we indeed have a very strong case. We have responded. We've attended all the pre-trials that we've participated as best we can. We are not throwing in the towel. I'm simply saying on that score, Your Lordship, is the defendant's case hopeless? Not a chance, Your Lordship.
Yes.
When you look at the legal issues, I believe the plaintiffs
Yes.
have a bit of a mountain to climb. Lastly, Your Lordship, because that goes to the merits, so I don't want to go any further with that proposition, it's whether the defaulting party intends to proceed. And the short answer is yes, we are ready, Your Lordship. even as they change the sequence of witnesses, Your Lordship, we will be ready. If we need time to prepare, we will ask for a indulgence from the court at the appropriate time. But as of now, Your Lordship, we are ready to proceed as soon as we're done with this application. Your Lordship, might I very briefly just underscore the categories of discomfort that led to our objection.
Is this now in reply? I don't think that is
Your Lordship,
in reply.
Your Lordship, these...
That should be something stated at the beginning.
Your Lordship...
And I don't think it's really necessary. It's apparent from the papers why. The why is that the defendants are unhappy with the manner in which the expert notice have been prepared and the fact that there are copious annexures attached. I think that's the sum total of it. And that's what you have argued. I don't think we need to deal with that again now.
Your Lordship, that's 2 pages that I've now skipped because the court is satisfied with the submissions that have been made as the court sees it.
Yes.
I will just deal with the question of prejudice, Your Lordship, at this point. Most importantly, because the plaintiffs have failed to comply, in our view, with the Rule 36(9)(b) notices, in the respects pointed out by us. It's not wholesale, in the respects pointed out by us. The defendant was compelled to bring this application. Prejudice is the theme, Your Lordship. There is a cost element to an application of this nature, both on the part of the defendant and when one considers the administration of justice, judge's time, the allocation of dates for a judge to spend on a matter such as this. Again, the further context, Your Lordship, is all this time has been allocated to a matter that has a large number of documents that are of no relevance to this case. That's our version. Prejudice, Your Lordship. Who has occasioned prejudice to the administration of justice, to the parties? I would like to submit, Your Lordship, that it can't be the bona fide effort of the defendants that has caused this prejudice that has been spoken of. Your Lordship, in any event, were the court to find that prejudice has been occasioned, there are remedies, Your Lordship. Again, back to either the further alternative relief or the types of sanctions a court may want to impose. Appropriate cost orders, it depends. There's an arsenal of remedies that are at a court's disposal. So really the question of prejudice, Your Lordship, is one that in our submission really does not fall squarely on the shoulders of the defendant.
Yes.
Because what the defendant did was try and come to the assistance of the court, because it's its duty to do that. In essence, Your Lordship, the defendants submit that in the event that this court is not able to grant the relief sought in that prior to of our notice of motion, then granting further an alternative relief might require this court to consider an extension of the case management process, a directive, as another alternative, Your Lordship, that a joint minute be prepared, because really that is what would assist this court. A directive to the parties within a particular time frame to convene a meeting of all their experts and to report back to this court.
That has been dealt with in chambers in the course of this week and even at the meeting that was held in my chambers previously, prior to this week.
Your Lordship, my submission really is, it is in the interest of justice.
Well, the impression I get is that the parties are unable to come to an agreement. It has been discussed. In fact, Mr. Bokaba was one of them who said that he would like to see that the experts meet and joint minutes be prepared. And if they're not able to, I leave it at that.
Your Lordship, we're in your hands.
Yes.
I do underscore the submission. You know, as I did yesterday.
Now, all I'm saying is that, so I don't see what purpose it will serve to now have a further delay by saying go and have a joint meeting of all the experts, because everybody seemed to be at idem that if it's possible, let the experts get together, let them discuss, come up with a joint minute. And I did indicate that preferred route from my point of view. And if the parties are unable to, I'll deal with the matter in the course of the trial.
Yes, Your Lordship, it's a time-saving measure,
Yes.
but I have understood.
No, certainly it would save time.
Yes,
Yes.
I have understood what Your Lordship is communicating, not only to us, the parties, but to interested parties and to the public, that you
Yes.
have made all effort, Your Lordship, and I do concede that you have.
Yes.
Your Lordship, I close with because Your Lordship's indicated that the categories are fully understood, they're set out in the papers. I will now just close with the matter of the costs order. Ordinarily, we would seek costs against the plaintiffs, Your Lordship. However, we appreciate that this court may not be in a position to evaluate all the submissions that have been made and all the supporting case authority that has been placed before the court. Of particular relevance, of course, is that response to that the defendants have made to the plaintiff's Rule 37 notice, which indicated quite clearly that we were going to approach this court for a striking out application. Your Lordship, the question of costs are most probably, Your Lordship, best reserved for a slightly later time. And I make the submission, Your Lordship, quite selfishly for the defendants, because I believe that our strategy, our approach in launching this application will be vindicated.
Yes.
In the premises, Your Lordship, the application should be upheld and costs reserved.
Thank you.
Court, please.
Well, if the application is upheld, then the defendants have succeeded.
So what?
I think you mean if I
The
decide
striking out.
against in other words, if I refuse the striking of application, then you would want the costs to be reserved. That's how I understand it.
Yes, Your Lordship, yes. I turned it around for a minute. Thank you.
Thank you,
As the court,
Mr.
please.
Kabashi. Mr. Willis?
In reply, I hope to persuade your Lordship that you should uphold the application by virtue of what you heard in reply.
Yes.
It's our submission that our learned friends or the plaintiffs have failed to address the issues in reply. In other words, the argument I'm going to put forward to you is that the reply did not assist your Lordship if your Lordship would otherwise be inclined to take the route that they propose, which is to dismiss our application. I hope by the end, my Lord, to persuade your Lordship that in fact their attempt was nothing more than one to muddy the waters. And I want to clear that up, my Lord. I want to be able to show your Lordship that there's no substance, that your Lordship can see the wood for the trees, and that the applications before the Lordship are indeed bona fide. My Lord, the real issues that were placed before your Lordship are twofold. The plaintiff's compliance or non-compliance with the rule. And then the second essential requirement is whether that compliance gives rise to prejudice. So those are really the two main strings. My Lord, there's this continuing theme that has been harped on about delay and last-minute actions. I'm going to address those before your Lordship, including with reference to authorities, my Lord. But, my Lord, on the facts, and Mr. Bashi has already alluded to this with your Lordship, there has been a continuing objection. My Lord, I would also ask your Lordship to remember that our application, once again, is nuanced slightly different to that of estates. We say, my Lord, in our application, it's properly reasoned, it's a proper strikeout notice I submit to your Lordship. We'll deal with the timing of it in the course of my submissions. But, my Lord, we specifically say all the articles must be struck out. My Lord, if I could just make sure that there's no misunderstandings, that's struck out of where they are. They can go into the trial bundle, my Lord. Of course, my Lord, once they're out, then, my Lord, the emperor has no clothes. One can then see the nakedness of the summaries, my Lord. So, Lord, there's been no delay in this trial. What has been happening in this trial, my Lord, are essential preliminaries, which I'm going to demonstrate with reference to authority in a few minutes, my Lord, ought to happen before your Lordship in the trial. There's no interlocutory here, my Lord, that ought to have been brought earlier. And if one has regard to the development of the dispute, it was never going to happen earlier. There has been a large degree of cooperation between the parties in the matter to ensure that the matter goes to trial and stays on trial. You do not have defendants before you who are seeking a postponement at all. Every issue that's been raised before your Lordship, my Lord, are the defendants standing firm on their rights. Ultimately, my Lord, it's to ensure a proper, fair and just trial before your Lordship. My Lord, the first problem that I want to focus on, my Lord, is this, and it started right at the outset of the answering submissions to your Lordship, was that of this allegation of vexatiousness. And, my Lord, we submit that that theme and that argument, my Lord, is a ruse. It's a red herring. My Lord, I will take it to the authority in due course, but to preface where I'm going, my Lord, is your Lordship, if your Lordship's going to make a finding of vexatiousness, your Lordship cannot make it on probabilities, preponderance. Your Lordship will have to make it, it must be a certain finding. I'll take it to the authority in due course, my Lord. So, we ask that your Lordship pay careful attention to that, but I want to start with the allegations of vexatiousness. Our learned friends for the plaintiffs started off and they raised the following points that they say pointed to vexatiousness, and I'm going to have to deal with each one, my Lord. They firstly started off saying, and I may not have the order precise, but I think I do have all of them, was to compare this to the leave to appeal application. My Lord, very briefly, we've been there, following brief submission, my Lord. Your Lordship witnessed the leave to appeal application, as Mr. McCorry called it, being a continually moving target. And when finally the issue, in accordance with the rule of law, had found itself to a point, there was then another mechanism, which we didn't. That was our case all along. We had a problem with FOCFA, we refused to have them controlling it. finally, that's where the defendants ended up, my lord, in principle, not a matter of principle, that's where they ended up in principle, that was the outcome, but not without a costs order. So, my lord, I think the result, the proof is in the pudding, my lord. The second point was a comment of an apathy to progress the matter. There's just simply no truth in that. Every effort has been made by all the parties to progress the matter. And if that's a reference to the legal representatives for the defendants, well, my learned friend Mr. Bokaba has already made his sentiments known on record, my lord. Of course, we align ourselves with those. A similar allegation or submission made was in the words, a generally obstructive attitude. That again, my lord, is really a reference to the legal representatives, because it is us who advise our clients on their attitude, on their rights, and on the course they can take, what their remedies, their relief is. Lord, there's simply no truth in that. Every effort has been made, not only to keep the matter on track, my lord, but to protect the interests of the defendants. And then, my lord, there was a reference to lateness and lateness in the day. I'm going to come to that just now, my lord, in the course of my submissions. There's no lateness in the day, my lord. Everything has happened appropriately with respect, and I wish to show that to your lordship. And then the other point that was made was this, as our learned friend said, and I objected at the time, you'll recall, my lord, by way of a comparison, to say that the defendants are guilty of the same thing. Lord, there's just absolutely no substance in that. Lord, this entire approach of muddying the waters, of putting up a ruse, is just pure deflection from the two real issues that I started out referring your lordship to, namely compliance or non-compliance and the defendant's prejudice. Our learned friend started out, just bear with me, started out by referring to the notice of motion and the relief of the first to seventh defendants. No reference was ever made to the eighth defendant's notice. There was no reference in reply to that notice. I don't particularly understand what the point is. I didn't understand the point, still don't, that our learned friend sought to make by referring to the notice of motion. But if there's any doubt, my learned friend, Ms. Kabashi SC, has made submissions to your lordship, and I started at the outset by reminding your lordship, or telling your lordship, that ours is, it is rationalized in our notice. I don't want to go back and read and waste time, my lord, but the articles need to be removed. Lord, I'll show in due course that those articles have absolutely no value in their admission, in their attachment.
You've argued that in the main argument. We're now dealing with reply.
Yes, no, I'm in reply.
Yes.
The submission was made that the defendants had argued that the summaries were devoid of evidence, and that's the point your lordship has made. But it wasn't in fact argued like that, my lord. But it came up in the reply, and I'm going to go back to where that came up. Lord, the question of which rule was applicable My learned friend has dealt with Rule 30A. And there's this harping on about 10 days and not 10 months. Your Lordship will remember, and you were reminded of this in answer, my Lord, that the time periods set in the case management meetings are not in accordance with the rule. So many months were set apart. So the reference to 10 months, my Lord, is of no value. But my Lord, insofar as it relates to the strikeout application being brought at the trial, your Lordship will know from the rules that there's no procedure that specifically deals with strikeout in trials. There is, however, constitutional authority, my Lord, which I will take you to in a short while. I first want to make my submissions to your Lordship, that where we do find it in the rules, my Lord, your Lordship is guided. And of course it happens in practice, my Lord, all the time.
You're referring to matters such as these where it's not, the striking of application does not relate to pleadings. Are you saying it in that context?
Yes, in
because
fact,
obviously Rule 23
yes, Rule 23
provides
we
for
don't
striking
rely on
off in
Rule 23.
pleadings. Yes.
We rely on, Lord, I'm going to take your Lordship to Rule 6 to show your Lordship how it works. And your Lordship knows, but you'll forgive me just for the sake of rationalizing my argument, my Lord, laying out, and your Lordship does that week in and week out, dealing with those applications in the opposed motion.
Yes.
But I'm going to go there, my Lord, so your Lordship knows where I'm going. Your Lordship recalls our case is Section 73, but prior to Section 73, 173 in the Constitution, my Lord, at common law, the court has always had the inherent power to strike out vexatious claims or parts of proceedings. Your Lordship would have dealt with this, I'm sure, but one deals with if, whether the matter is frivolous, improper, institution of whether there's sufficient grounds, irrelevant material, inadmissible evidence. Our learned friend took your Lordship to, in dealing with Section 173 in answer, he referred you to the matter of State versus Mlungu. I think you did take the citation. Would it be good for your notes here, my Lord?
You said it's the State versus?
Mlungu.
I have the-
Constitutional Court judgment.
Yes.
Mlungu.
I was looking for Mhlungu.
And I'm indebted
I have the citation.
If I should just see. Now, Lord, the fact is that that authority does, and His Lordship Mr. Justice Kentridge was not concerned with the authority for the exercise of Section 173. Just bear with me. Lord, what that matter is authority for is the principle of constitutional avoidance. It's got nothing to do with the application of Section 173. My learned friend never proffered any argument. His submission ran suddenly short. He never proffered any argument before your Lordship to suggest that we could rely on Section 173. But the effect of his submission was nonetheless to cast doubt in your Lordship's mind as to the application. Lord, just for the record, the principle of constitutional avoidance requires a court to first try to resolve a dispute by applying ordinary legal principles interpreted or developed with reference to the Declaration of Rights before applying the Declaration of Rights to the dispute. So, learned friend's reference to that case, my Lord, was without merit. and a muddying of the waters, my lord. If I remember correctly, my lord, it was at around this point in time that the submissions and answer switched over to a pointing to non-compliance with the rules, which has briefly been dealt with by Mr. Bashi SC. And, my lord, the authority on the rigidity in the application of rules is where I want to take your lordship next. If your lordship would just bear with me. My lordship, I do have a note here which I'm paging through now, which we had not intended to hand it up to your lordship, but I subsequently thought it would be helpful to your lordship. I'll hand it up. In fact, I have a copy here, my lord.
Do you intend to deal with the issue about the rules are for the court and not the court for the rules?
That's already been alluded to. Your lordship knows the principle.
Yes.
I'm just going to. Now, my lord, where I would like to go now, my lord, is to. Let me leave it now, my lord. I'll hand it up to your lordship for the benefit afterwards. Allow me to just develop the argument, if I could. Lord, in McAdam, there's Pioneer Foods.
McAdam.
McAdam, M-U-K-A-D-D-A-M.
McAdam.
And I'll hand this to your lordship just now, and you'll have it in the notes, my lord. The Constitutional Court, dealing with the right to a fair public hearing before a court in terms of Section 4 of the Constitution, I find as following. Flexibility in applying the requirements of procedure is common in our courts. Rigidity has no place in the operation of court procedures. That's not to say, my lord, that in the right circumstances, where there's prejudice, the lordship is not or ought not to be inclined to enforce a rule. So we have Cooper, my lord. In Cooper, and I'll return to that later, in Cooper there's a comment to that effect, where the Supreme Court of Appeal encourages judges to enforce that rule. But of course, my lord, it's all in the exercise of discretion, I accept. My lord, it goes further to say the proper approach of the courts is not to treat rules as dogma. The rules of court, which constitute the procedural machinery of the courts, are intended to expedite the business of the courts. My lord, that's the very premise of our application, and will be interpreted and applied in a spirit which will facilitate the work of the courts and enable litigants to resolve their differences in as speedy and inexpensive a manner as possible. The court also has inherent power to adapt the provisions of the rules to meet particular circumstances and prevent abuse thereof. As has often been stated, the rules are made for the court, etc. As your lordship knows. Lord, we've also included, nonetheless, a reference to Kuno. This is Spira and Son. I'm not going to read it. Your Lordship will see it in the note by His Lordship, the late Acting Mr. Justice, Lordship Slomovitz. And then Ecker versus Parsons, my Lord. And this is the balance. Without doubt, rules governing the court process cannot be disregarded. So that's not our submission, my Lord. They serve as an undeniably important purpose. That, however, does not mean that courts should be detained by the rules to a point where they are hamstrung in the performance of core function of dispensing justice. Now, my Lord, the same argument might be that, well, it's a double-edged sword because we're looking for the enforcement of a rule. Your Lordship may think, in your own thoughts, that, well, what difference does that make? My Lord, we must just show your Lordship the prejudice. And once we've established the prejudice, my Lord, we say that that should swing the balance. And,
so I think you should deal with that.
Sorry?
I don't think you need to amplify further the issue about what the rules are for the court and not the court for the rules.
All I'm saying, my Lord, is...
It's well known.
Yes, but my submission, my Lord, I'm merely making clear to Lordship, my submission is a balanced one. I'm not simply contending for one without recognizing it as your Lordship. Sorry, my lord, I just want to check.
Yes.
Lord, I'm going to continue until approximately tea time. Is that in order, my lord? Or because we started earlier, that's the only reason I'm making the inquiry.
Yes. You still have much to say.
Yes, my lord, I'll proceed.
In reply.
Yes, in reply. Well, my lord, I have to deal with what was raised in answer. And if I revert to arguing what was argued, my lord, please stop me and I will gladly,
Yes.
desist. My lord, the strikeout application, and I submit, notwithstanding the first to seventh defendant's answer to which rule, and Rule 38 in particular, notwithstanding that's the approach taken by Ms. Kuvashi and the first to seventh defendants and ours being under Section 1.
Did you say Rule 38? No.
30A.
Oh,
30
38.
capital A.
Oh.
Yes, 30 capital A. That this argument applies equally, my lord. In fact, on the very premise of what I've just read to you, my lord, and if I might underscore that myself, it's the words as out of Macadam. The court also has inherent power to adapt the provisions of the rules. So, my lord, I'm going to turn now to Rule 6:15, and this is the rule that we all learn the practice of strikeout applications in. And my lord, with respect, we as practitioners have applied it all of our years. Many of us, some of us in this court for more than 20 years, my lord, have always applied it in the same way in trials and applications alike. And that's why you see an application for strikeout being brought on the day of trial, my lord. There can be some criticism, my lord, that, well, why didn't we launch it in the days preceding, in other words, after that meeting in your lordship's chambers. My lord, there was still hope that the matter was going to be resolved. And if that hope was ill-founded hope, my lord, there's a lot of other preparation, and we were all, certainly on the defendant's side, pretty engrossed in in preparations to readdress your lordship on the issue pertaining to the media access, as you know, my lord. But my lord, in Rule 15. I might just... Rule 6:15 deals with that the court may on application order to be struck out from any affidavit, any matter which is scandalous, vexatious, or irrelevant, with an appropriate order as to cost, including cost as between attorney and client. The court may not grant the application unless it is satisfied that the applicant will be prejudiced if the application is not granted. Now, my lord, that indeed relates to applications. But my lord, that's precisely the rule in which, it's not the rule that is used, but it's precisely the practice in all strikeout applications. Now, if we go to the commentary in Erasmus as the easiest point of reference.
Isn't Rule 23 used, you're saying all strikeout applications?
Well, obviously not strikeout applications in an exception, because, my lord, ordinarily in an exception, you can either bring out a separate strikeout under Rule 23, or it might be not an alternative, a further prayer in your relief, my lord, in an exception. So I don't refer to that. I'm talking about strikeout applications. There's only two places one reads of strikeout applications, as I recall, my lord. And that's in Rule 23 and now in Rule 6:15.
Yes.
But, my lord, strikeout applications in trials, in trial matters, is very common, my lord. The commentary is in service, this is service 2 of these latest reworks by Jeter, my lord. That's at D190, D1-90 page. And this is the commentary. I appreciate it relates to application of the principles.
Is this from Erasmus?
Sorry?
Erasmus.
Yes, Erasmus.
You say page?
D190. I did notice your lordship referred to Hurrams earlier.
19 or 90?
90.
90.
If your lordship would like a copy, I could also arrange that for your lordship.
No, it won't be necessary.
Sorry?
It's not necessary, thank you.
Lord, for the sake of proper context, I'll just read everything here. Several regulates the striking out of matter from an affidavit as opposed to an application to strike out an entire claim that is vexatious. And that's what we're doing here, my Lord. It's matter that we're striking out. In the latter instance, the court enjoys a common law and inherent power to strike out claims that are vexatious, by which it is meant frivolous, improper, instituted without sufficient ground, to serve solely as an annoyance to the defendant. As a complement to the common law, there's the Vexatious Proceedings Act. The application must be on notice in terms of Sub-Rule 11. Well, all of us have, both sets of defendants have placed it before your Lordship on notice. The application must clearly indicate the passages to which the objection is taken and set out the grounds of objection shortly. There's been no attack on that, my Lord, that it's deficient in that regard.
But what you're reading from Erasmus is in relation to
applications.
Applications.
Yes, but the principles I submit to your Lordship are the same, and this is how your Lordship is able to simply adapt it. My Lord, the striking out of entire expert notices takes place in the course of trial. In fact, my Lord, our interlocutory courts have become rather defunct in most of our divisions, but these are things, my Lord, that one can only really properly deal with before the trial judge. It's often unfair to raise matters such as that. And in fact, sometimes it's better after your factual witnesses or plaintiffs ordinarily have given evidence, then there might be a strikeout application, my Lord. It can arise out of the evidence that's brought by the plaintiffs giving factual evidence, simply because they might end up narrowing their case, and then it becomes irrelevant, my Lord. So, my Lord, it's not abnormal at all. And here's the point, my Lord. The application should be set down for hearing at the same time as the hearing of the main application. That's how it happens in applications, my Lord. But then the reason for that is the judge then has everything before him or her. Lord, the authorities for that are in Erasmus. I'm not going to waste your Lordship's time. It's under footnote 8. So, my Lord, it continues, since an application to strike out objectionable matter in affidavits is dealt with only at the hearing of the main application, a party must in his opposing affidavit deal with the application sought to be struck out. By doing so, he does not waive his right to object to the offending allegations in the affidavits. So, my Lord, that's precisely, my Lord, the respect that has taken place here. And the allegations of delay and late hour in the day, my Lord, do not fit into the facts and circumstances before your Lordship.
See, the difficulty, and I raised this yesterday.
Yes, my Lord.
We're dealing with expert notices relating to experts who intend to testify at the trial on various aspects.
Yes, my Lord.
Which is different from where you have an application where a case is laid out and so on. So you are now saying that the same rule, principles rather, should apply.
Yes,
in relation to this striking of application about experts.
Well, Lord, my submission is further. It's further than that. It extends further. My submission to your Lordship is that is precisely how it happens in trials. That's what happens. That's what the trial strikeout applications are heard in trials all the time, my Lord. Your Lordship and I are not. We're not disagreeing. There's no disagreement on that. There's no rule that caters for it. But it's really, at the end of the day, something that is performed under the court's inherent power.
Yes.
And I'm just pointing to the principles your Lordship finds under 615, which specifically deal with that, my Lord. The Lordship, and of course, the adjunct to all of that, my Lord, is that your Lordship's looking for prejudice. It's just one of the principles that might be helpful to your Lordship. See, my Lord, if I refer your Lordship back to Rule 611, that deals with the fact that applications are incidental to pending proceedings, my Lord. An application is incidental to pending proceedings if it is subordinate or accessory to, while at the same time being distinct from. A legal issue should be decided at the interlocutory stage of proceedings, only if it would result in the final disposal of either the matter as a whole or a particular aspect thereof. Matters in which an order, judgment, or direction is sought from a judge sitting otherwise than in open court may in division be brought in chambers. And then one has the book, the chamber book approach, as in other divisions. But my lord, here, this was the only place we could have brought it. The only real criticism that could be levelled, my lord, with respect, is that after our meeting with your lordship on Thursday, the 20th of July, that maybe sometime after that, when hope of resolution ran out, well, then the strike application should have been brought. But that's really that's the high water mark of any criticism that can be levelled at the defendants. But my lord, as our learned friend points out to your lordship, context, and your lordship has an explanation. In fact, your lordship has experienced the efforts to bring this about. But ultimately, my lord, the failures and delay in relation to what we're really facing in this trial could have been solved if the plaintiff had got joint minutes done. In other words, and I'm going to get there in a moment.
Mr. Willis, I'm just concerned that you're again traversing what was said in your arguments in chief.
No, with respect, this time, my lord, this is not. I didn't address this at all to your lordship in
well, it's another way of saying the same thing.
Well, my lord, I'm dealing with the reply of Mr. Mahon.
Yes, but what is it that you are replying to now on this point that you've just said? You said that in your when you gave your main arguments yesterday.
No, I didn't, my lord. I didn't. I started with two things to say to your lordship. The high water mark of the criticism is that possibly we ought to have brought the application first. And the second point I'm making to your lordship, just want to focus it, my lord, is that the efforts to bring about a resolution, the other outcome which may have resolved the dispute before your lordship, in and around the prejudice suffered by their notices, their summaries, reported summaries, is had the plaintiffs met, it may have been resolved, my lord. My point to your lordship is that the plaintiffs did not meet, or the experts did not meet, my lord, not because the defendants prevented it. It's because the plaintiffs and their experts didn't initiate that process properly, or in fact, there were intentions to do it, and I want to take you to the correspondence and the pre-trial minutes. It's the plaintiff's responsibility to secure, and if the defendants are obstructive, that's an answer. But you are not, no submissions, as I recall, the Lord would place.
All right, Mr. Willis, can we move on? Because this application is taking far too long, and I think you need to move. You made your certain points very clear, but can we move on to the next point? I think your main issue here is about the prejudice.
Yes.
Let's deal with it.
Well, okay, so let me try.
I think you've traversed the issue about the rule under which this application brought you. You mentioned yesterday Section 173. Today you've referred to the various Rule 6 and etc. I think you've covered that, unless there's something else that you still want to.
Yes, no, say, my lord, that you took issue with the state's approach and even to the point of not wanting to accept a late condemnation application. My point is we don't even need a condemnation application, my lord, on the basis that I'm proper, your lordship. But I think your lordship understands that.
Yes.
But my lord, remember, I'm still dealing under vexatiousness here because this is all a ruse put forward to your lordship, that it's us to blame, the defendants to blame. My lord, your lordship was just briefly referred to the pre-trial minutes yesterday. And my lord, it's important that your lordship have regard to the minutes. I want to my lord, might I just inquire your lordship? What I want to deal with here, my lord, is this whole argument that about the plaintiffs, that the defendants are the cause of you not having joint minutes, that it's one of the delays. In other words, it's the very premise that if you had joint minutes, maybe all of this would have been resolved. And we would still like to think that if we could get the experts to meet, because that has been tendered over and over and over by Mr. Bokaba. If it could happen, that all of this could be cured for the benefit ultimately of the court and the trial, my lord. But if your lordship is going to accept that that's just not an issue here, then I can stay away from the minutes. But the minutes demonstrate cooperation all the way, my lord. My learned friend cast a picture before your lordship of disagreement and obstruction. My lord, there is no such thing recorded in these minutes. If your lordship reads them minute after minute, there's even agreement on the Scott schedule. When I say no, it's not agreement. It's agreement in principle, but there are doubts as to whether it's functional. But where the matter was rested, ultimately, was that the experts must meet. And that's the whole point, my lord. It was the plaintiff's responsibility to ensure joint minute. They don't put up a case. The reference to the minutes is to suggest that, well, we were obstructed. My lord, there is nothing in here to make it a case for obstruction by any of the defendants, my lord. And my lord, in my case, the Doctors for Life, the 8th defendant, our experts know each other. They have debated each other in public. There's no reason why Dr. Abrams, Professor Nutt couldn't make contact with our expert. In fact, we provided those contact details. One of the minutes, in fact, relates to how she is sensitive around her contact details because she unfortunately is a target by drug cartels in the United States. But those details were obtained. Well, my lord, I don't think they can point to one effort by any one of the experts making contact with the other experts of the defendants and procuring an outcome. And they were prepared for that, my lord. Lord, I'm going to leave that there, but it's a very, very important point, my lord, because that aspersion has been cast not simply over any of the experts, it's actually been cast over counsel in the matter ultimately. And if it's not intended solely for counsel, well, then it includes the attorneys, my lord. My lord, then there was a reference to the trial bundles that were handed to the plaintiffs yesterday. Was our trial bundle. It is indeed so that the state's trial bundle is still to be put into the files, as I understand it, my lord. My learned friend
So
said...
it's your trial bundle of the 8th defendant?
Yes.
Yes.
I was just saying, the first to 7th defendant's trial bundle is yet to be stuck in. But my lord, firstly, the first submission that was made was that it was thousands of pages. No, my lord, I think it's just over 1,000. I think it's not even 1,100. That's the first. But it's a lot of paper nonetheless, my lord, we can see. But my lord, what does that have to do with this application, except that it's part of the ruse, the muddying of the waters? There's no, as I said to your lordship, there was a great air of cooperation in this matter from all sides, my lord. No party above the other. Everybody worked hard to ensure that this trial would run. And, my lord, that cooperation went to the point where there's no need to make discovery and spend time on discovery affidavits and costs. And so, my lord, there's been no complaints until yesterday in answer, suddenly. And that, in any event, there's no application before your lordship. And there was no demonstrable prejudice argued to your lordship. Lord, then, I think this is then the last point on vexatiousness. Our learned friend then sought to compare the expert summaries of the plaintiffs to the defendants. Well, my lord, there's never been one complaint about our expert notices prior to that. Secondly, you know that the defendants placed on record, the 1st to 7th in particular, 27th of March, they placed on record their complaint, and as Mr. Bashi SC argued to your lordship, it was a continuing objection. but there's been no application against those, never mind no complaint, there's no application. Lord, that criticism was without merit. Our learned friend for the plaintiffs took you to Mr. Bayever's report, if I get his name right, and read a small little extract from it. My Lord, there was no merit in that criticism at all. You can't criticize without reading the entire report in any event. But there's no need for your Lordship to even go there. Lord, then as to the criticisms on the notices, my Lord, just to reiterate what our case is, we say that everything should be a summary. My Lord, if the summary is compliant, and there are all of these annexes to it, my Lord, even then there's a ground to strike them out. Because just by attaching them, they can't become evidence. They can't become evidence. I should take you, I'll learn to quote it from Hoffman and Zeffert, the fourth edition. He read to you what he did there, my Lord, but it's at 101 that you read. If the expert refers to books or articles in support of his views, they become evidence only insofar as he has adopted them, with or without comment, as a part of his evidence. And so, what's been placed before your Lordship is really irrelevant, superfluous, waste of paper. It shouldn't be there. Everything has to be in the summary, my Lord. This is with respect, I've never seen an annexure of this nature onto a summary, and I've certainly never constructed one. It's not how ours lie, but our prejudice lies in the fact, my Lord, that we don't have the underlying facts in summary. We don't have the ratio in summary. At best, we have opinions, my Lord. And your Lordship will recall, and I can give you the page number for each and every summary, is that standard clause which reads, it says that it's expanded upon in the articles. No, that's incorrect, my Lord. There's no summary on the ratio. You left the defendants are left guessing. My Lord, our learned friend referred to sorry, my Lord, you should bear with me. The matter of state versus Kimimbi, my Lord. If you recall that reference to your Lordship yesterday,
Yes.
it was given to you, the citation. It was turned around, your Lordship will remember, Lachevich and Budden, their two articles, and whether they were qualified or not. Lord, that's not the point that we take. We just take the point that we want the summaries. We want their evidence summarized, my Lord. And the problem there, my Lord, is that the attack from the state side on particularly Lachkovich and to a lesser degree, if I recall correctly, Budden, is that they're not experts. My Lord, I don't care whether they're experts now, we can deal with that in cross-examination. But they can't sit as laymen, my Lord, and just simply rely on an attachment. Your Lordship takes my point. It must be summarized. We can test in evidence whether their summary is theirs or their opinion is theirs or not. But it needs to be summarized. And you've got Lachkovich, who attaches those 400 pages, was continually referred to. My Lord, we need it summarized.
Yes. Yes.
Thank you. My Lord, the comment that our complaint is that we've given them too much notice. No, my Lord, that's not at all our complaint. and being cognized with which articles you're going to bring in case
Sorry, what
about.
did you mean by too much notice?
There was the submission made by Mr. Mahon that our complaint is that the plaintiffs are giving them too much notice. It was shortly after that that Mr. Bokaba rose to record an objection, my lord. But, my lord, I think that brings us to the crux of the matter, my lord. No, we're not cognized. By simply attaching the articles, we're not cognized with prejudice. My lord, what is your lordship to do in the circumstances? Well, my lord, the possibilities. We seek that you strike it out. In relation to costs, my lord, if we are successful, then your lordship ought to grant costs. Your lordship pointed that out to Mr. Kabashi, and I, with respect, agree with your lordship. If your lordship is disinclined to uphold these applications, I accorded that submission, my lord. Reserve the costs. Your lordship will find out in due course, and it won't be difficult to revisit the issues, my lord. My lord, could more come of this application? Yes, we would say so, my lord. Your lordship expressed reservations earlier in this Kabashi's submissions to your lordship, but I think, my lord, if your lordship gave a directive, we have then, at least as the legal representatives, we have something to work with. Let's forget about the argument. Your lordship can achieve the objective. It may take some time, but we believe, my lord, the time taken will save. We could finish this trial.
And what would you have in mind in the directive? What should be in the directive?
Directing, like for instance, my lord, which experts must meet with whom. So we know the only experts of the plaintiffs that my expert deal with is two. I have a psychiatrist, Professor Zaba, and then Professor Madras. They need to deal with Dr. Abrams and Professor Nutt. That's it. The rest doesn't fall within their scope of purview. If it is, I should imagine that given, if we get proper summaries, my lord, of what the opinions are, I may not even have to call Mr. Evans, my lord.
Yes.
So, the Lord, if you directed who must meet with who, the parties might, of course, as a convenience to Lordship, help your Lordship with that. But I think we will know who those are. Lord, it's not for me to make any further submissions, I don't have those on this.
Yes.
My Lord, on the vexatiousness,
it's now...
it's just after tea time.
Are you still going to be long?
3 to 5 minutes when I come back, my Lord. I really want to just take the vexatious cost point.
We'll take the tea adjournment.
Yeah, we must you read the articles? And he said, no. Then he made reference to data and you must be taken through it. My Lord, that can never be right, because I must contrast that with his comments on ourselves as counsel for the defendants. He says that the advocates must trawl through the annexures. He says that's what we do for a living. My Lord, he himself conceded the annexures are above his pay grade. Well, they're above ours too, my Lord. We need summaries. Your Lordship has before you 880 pages of annexures, my Lord, nearly not far off 1,000. We need them summarized. They can go into the trial bundle. My Lord, lastly on costs.
So you're saying that where each expert says in the notice that this is my summary or opinion, etc., that's not good enough?
Well, that might be his opinion. And if he's going to stick to those opinions, fine, because...
So if he doesn't, you can then...
Well, we'll hold him to those opinions.
Yes.
They're not going outside...
So you can do that during the course of the trial?
Yes, that we can do.
Yes.
But how do we prepare on the opinion? How do our experts prepare on the opinion without a summary? The only way is we have to take each one of those articles, even though they're just something someone else read together with footnotes, and we have to read all of that, or together with our experts read all of that. Only then are we prepared for whatever might come.
Yes.
That is not the import of the rule, as our case is, my Lord. There has to be a summary, my Lord. Once there's a summary, and my Lord, your Lordship was 100% correct, and Ms. Gabashi conceded it with you. It's not about it being containing everything. It's a summary, my Lord. It's a summary. Your Lordship was correct.
So you said there's no summary?
There's just no summary on the ratio. There's no summary on the underlying facts. There's no summary. To some degree, there might be a reference to things. But where's the ratio? Where's the facts? My Lord, if your Lordship reads the Cooper case, in that matter, the objection came from the plaintiff in regard to the defendant's expert notices in respect to trials or tests or experiments that had been done that hadn't been summarized. The judge locked the defendant out. They locked those experts out because they weren't summarized. Here we told you must go and read these articles, and you were taken, by way of an example, to Annexure D for Dr. Abrams, to HIV. Well, my Lord, none of the plaintiffs suffer HIV. So I don't know whether that's going to arise on the factual basis. But be that as it may, my Lord, we are left to go hunting in the dark. We really are, my Lord. And so is your Lordship. My Lord, my submission to your Lordship is, if it's required of us to read it, my Lord, it is required of your Lordship, notwithstanding what's in the trial note and what our learned friends say, my Lord. Your Lordship should read what we read. That's the summaries. We should be on the same page as to what the issues are. The only difference is you don't need to consult with the experts thereafter. We'll bring that to you to court, my Lord. 880 pages, my Lord. My Lord, on the last issue on costs, vexatiousness, I told you at the outset, my Lord, I wish to make a submission. I'm going to actually hand up the authority with the note that I'm going to give your Lordship, my Lord. It is in the Dlamini case. It is Absa Bank versus Dlamini, the 2008 page 262 authority out of this division. Something's been handed up to your Lordship there, my Lord.
Lord, I believe it was intended for me, my Lord, not for your Lordship. I apologize.
Your copy's here, my Lord, if I can hand that up to your Lordship. Your Lordship. I need a copy. Lord, for your Lordship's convenience, I have flagged page 271 in the pink flag.
Yes.
Your Lordship, if I could ask your Lordship to turn there to paragraph 27. I'm only going to read the last paragraph, which is highlighted just above paragraph 28, my Lord. Whilst an action which is obviously unsustainable is vexatious, that's an action we're dealing here with an issue, my Lord, a certain matter. This must appear as a certainty and not merely on a preponderance of probability, and there are the authorities. My Lord, my client... My client too is a civil society non-profit organization. And that's
Yes.
why I've had to treat these allegations of vexatiousness so seriously, my lord, and conclude to draw this to your lordship's attention. Lord, those are my submissions in reply. I thank you for your lordship's patience.
Thank you, Mr. Willis.
Your Lordship, if I might, just address the court on one aspect. We had been discussing with my senior whether it wouldn't be prudent to have a short meeting with your Lordship in chambers now at the end of these proceedings.
Before I give my decision.
Well, it really is to deal with the joint minutes matter, your Lordship, and trying to see if your Lordship is in a position to assist us. So it would
Yes.
clearly be after your Lordship has determined this. It's just for that little
for that
aspect
purpose.
to be dealt with. Yes, your Lordship.
Yes. Let me just hear what the view is. Mr. Willis, you heard what Ms. Kawashi says?
I have no objection.
You have
Lord.
no objection. Mr. Mahan?
Lord, I'm of course always willing to listen, my Lord, but it's late in the day to start discussing experts, my Lord. In that discussion, we'll point out, my Lord, that on Monday, my instructing attorney sent an email saying, please urgently let us have your proposals in regard to facilitating a meeting of experts to draw up a joint minute. No response to that email as we sit here today, my Lord. My Lord,
Yes.
to try and do that, my Lord, I accept that a joint minute and a meeting ordinarily will curtail the trial. But that's not going to happen given that how far we've come, my Lord. It's going to take, firstly, as I understand it, some of the experts are not even in the same time zone. If they arrange the meeting, that could take another day or two.
Perhaps we could have that discussion then in chambers. Now the question is, this is the end of the striking of application. I would have to give my decision on that. What is the more prudent course? That I give my decision first and then deal with the issue of a discussion about
Yes,
the
my Lord.
experts?
In our submission, you should give your Lordship's order on the strikeout application. And quite frankly, my Lord, I anticipate that there's going to be differing views on the meeting of experts, so it ought more properly to be dealt with in open court, my Lord.
Yes, because my concern is, that is why I posed the same question to Ms. Kabashi, and that is whether I should entertain this application or discussion in chambers before I give my ruling. My view is that I should first give my decision, and then we take it from there. I don't want it to be in any way construed that anything that's discussed in chambers after having had an open court hearing relating to the striking of application, that might have influenced my decision. I think I need to make my decision on the facts as they were presented
As your Lordship.
to the court.
As
So,
court will.
thank you. So I'm going to adjourn and just for a few minutes and come back and give my decision, and then we will deal with the question of a discussion in chambers. So the court adjourns for a few minutes. in this application for striking off by the first to seventh defendants and the eighth defendant, I had before me two applications by these parties. I've heard them, or rather I've heard the submissions by all the parties, and I make the following order. By first to seventh defendants and the eighth defendant are dismissed. 2, costs are reserved for argument. Reasons for the decision will be furnished in the main judgment.
As your Lordship pleases.
At this stage, I will adjourn.
Listen, I've been
Mr. Mohan.
Thank you, Lord. Well, before I start with my opening address, innocuous notice of intention to amend was delivered by the plaintiffs some few days ago, simply changing a clerical error in the prayers relating to the wrong schedule. That then formally move for that amendment, my Lord. During the next adjournment, if it pleases your Lordship, if your Lordship would be so inclined to make your files available, we will insert the amended. We would like the opportunity to replace some of your pages with color versions. I suspect your Lordship may only have black and white versions of some of the pages in your files. We would like the opportunity simply to
Mr. Bokaba, about the amendment, there's been no objection. No objection. No objection. And Mr. Willis? Also. Thank you.
as it pleases the court.
Yes.
Thank you, my Lord. Lord, as your Lordship is now well aware, this matter focuses upon the extent to which laws that prohibit the possession and use of cannabis use and possession of cannabis, regardless of the purpose of such use and possession, and regardless of whether the particular plant in question is psychoactive or not. It's the plant that can make you get high. And your Lordship will hear in due course evidence about...
If I may interrupt you, when you said whatever, regardless of the use for which it is, for recreational use,
Correct.
And medicinal and that as well, are you including that in the...
Yes, my Lord, there's a... Perhaps I should qualify myself slightly.
Yes.
Under the medicine, there is a provision in the schedule which entitles someone to receive a permit, and that permit may be provided on such conditions as the Director General may, such as treatment of a particular patient or research,
Yes,
subject to that qualification.
I see.
But my Lord, from the outset, we must make plain and in particular remedies for the violation of the Bill of Rights, make serious inroads into the separation of powers principle. And we quote, my Lord, from Ferreira, in a democratic society, the role of the legislature as a body reflecting the dominant opinion should be acknowledged. it is important that we bear in mind that there are functions that are properly the concern of the legislation may overlap, but the terrains are in the main separate and should be kept separate. Thus, my Lord, the plaintiffs accept that it is not the role of this court or any court, my Lord, to dictate the possession and use of cannabis. The function of this court, my Lord, rather, and the relief which is sought by the plaintiffs, is to determine whether the present passes constitutional scrutiny. In short, my Lord, we do not require your Lordship to dictate to the legislature how to regulate possession and use. Simply to declare witnesses will express opinions on what they deem to be an appropriate and more effective legislative framework. These opinions, if not merely anecdotal, of the legal issues in this case. One, my Lord, its purpose is to demonstrate the irrationality which we submit exists in the present legislative regime. And because your Lordship will recall, in terms of Section 36 of the Constitution, any right can be limited, subject to a number of factors, one of which is whether there are evidence in regard to alternative legislative regimes, methods of regulation, etc. We don't tender that evidence in order to persuade your Lordship that your Lordship should order the by the plaintiffs is couched in deliberate terms. Your Lordship will have seen in the particulars of claim, pages 32 to 33, your Lordship need not go there for the moment, that in paragraph 26 inconsistent with the Constitution and therefore invalid, and that cannabis be removed from the list of substances listed in Part 3 of Schedule 2 of the Drugs and Drugs Trafficking Act. Of the Medicines and Related Substances Act, if I could call that the Medicines Act, my Lord. And that references to Dagga in Section 21 of the Drugs Act be expunged. The declaration of invalidity and the relief and consequence thereof be suspended for a period of 2 years to enable the legislature to pass appropriate legislation to regulate possession. So what the plaintiffs contemplate, my Lord, is that there is no intervening period of a free-for-all. Slightly different, my Lord, to the outcome which was achieved town, a provision for a defense which could be raised pending the legislative outcome.
Yes.
The plaintiffs challenge really three broad bases, my Lord. One, that the prohibition is irrational and inconsistent with the fundamental principles of the rule of law, does not, and my Lord, and this is pleaded, because the prohibition owes its existence to outdated and unfounded convictions on the harmfulness and dependence-producing effects of cannabis, motivated which permeated, unfortunately, my Lord, in our history. My Lord, it is necessary and relevant to undertake a brief recall for centuries, as it is reflective of the manifestly impermissible and unscientific moralistic justifications used. And that, my Lord, was the view taken by the full bench in the Western Cape matter. There was specific recourse to that historical context, my Lord. So, my Lord, repugnant notions held by those who are politically and economically dominant in our submission, my Lord, places an additional onus on the defendants tailored to the contemporary context to justify the infringement of the plaintiff's rights, viewed in terms of autonomous acts undertaken by people in relation to their own or bases of constitutional challenge, my Lord, are that the prohibition violates a number of the plaintiff's constitutional rights under Chapter 2, and of course that the prohibition cannot be justified as a limitation in terms a total of 9 rights in the Bill of Rights, my Lord, which are articulated expressly as being rights which are violated by the legislation. If I could just list them. Section 10. The right to freedom and security of the person, Section 12. The right not to be treated or punished in a cruel, inhuman or degrading way, Section 12. 14. Section 18. The right to ecologically sustainable development and use of natural resources, Section 24b(3). The right of access to healthcare services, belong to a cultural community, the right not to be denied the right with other members of that community to enjoy their culture, Section 31. And finally, my Lord, the right to there's a limit matter in the matter which came before the full bench of the Western Cape, at least insofar as the judgment is concerned. Again point out, my Lord, that that judgment is the subject appeal. One of the complaints is directed at the full bench having articulated the right which it sought to be violated but nonetheless, my Lord, the court in that matter found that the impugned provisions violated the right to privacy and were accordingly invalid. And despite the fact that the matter is being taken to the ratio decidendi of the full bench, and although not binding on your Lordship, would be of persuasive value.
Well, it's a full court decision.
Now, if I could just paint the picture of the legislative provisions which are under attack in this case. Section 3 of the drug apply, quotes, a scheduled substance. Sections 4 and 5 of the Drugs Act prohibit the use, possession and dealing of as defined. But if you look at Section 1 of the Act, the definitions section, to look for how it is defined, an undesirable dependence producing substance. But the definition simply says that if it is a substance or a plant from which a substance can use, my Lord, in terms of the legislation, the test as to whether it's an undesirable dependence producing substance has nothing to do with whether it's undesirable or dependence producing. The test is desirable dependence-producing substances includes the following substances or plants which are relevant to this case, my Lord. Cannabis, brackets, Dagga, dronabinol, and then in brackets it says trans-delta 9 tetrahydrocannabinol. It also includes tetrahydrocannabinol. That
Yes.
Now in parenthesis, my Lord, we point out that if one has regard to the schedule, other substances listed in the very same schedule as cannabis include heroin, and we will argue, of course, that that immediately raises some concerns because the schedule doesn't distinguish between drugs of that nature and the drug in legislated as a drug. Thus, my Lord, by virtue of their inclusion in Part 3 of Schedule 2 to the Drugs Act, it is illegal to manufacture, supply, and THC. The exception doesn't apply to THC. THC is also equally prohibited. It's only dronabinol, which is regardless of whether the plant is of such a nature as to include a sufficient amount of THC to intoxicate a person. And it even, on that definition, my Lord, includes industrial hemp fiber, such as pieces of plant which contain no psychoactive ingredients. Moreover, my Lord, we make this observation that and hemp fiber products. The value of such an amount of cannabis could easily place one who's found in possession thereof over the threshold render a person liable to a minimum sentence of 15 years imprisonment for a first offender and 25 years for a third or subsequent offender, my Lord. Substances. To make matters worse, my Lord, Section 21 of the Drugs Act operates, as you know, to create a rebuttable presumption that in the process there's a presumption that the accused dealt in Dagga if he or she was found in possession of an amount exceeding 115 grams, or merely the owner, occupier, or manager, or person in charge of the land. So if someone is making hemp products, my Lord, it's likely that he will have sufficient number of plants to 15 years imprisonment as a first offender, and also face the presumption, the reverse onus, which makes serious inroads, my Lord, into the globally recognized right of a person to be presumed. Cultivator of hemp products would be presumed to be a drug dealer until proved otherwise. We refer to Section 22, capital A, brackets 9, brackets small a, which says, my Lord, that no person any Schedule 7 or Schedule 8 substance, or manufacture any specified Schedule 5 or Schedule 6 substance, unless he or she has been issued with a permit Provided, my Lord, provided that the Director General may, subject to such conditions as he or she may determine, acquire or authorize the use of such a substance for the treatment or prevention of a medical condition in a particular patient, or for the purposes of education, analysis, he's not entitled to obtain a permit generally to treat patients for cannabis oil. It has to be done on a patient per patient application.
Yes.
Brackets Dagga, close brackets, the whole plant or any portion or product thereof, except when separately specified in the schedules, or processed hemp fiber containing 0.1%, that the product does not contain whole cannabis seeds and is in a form not suitable for ingestion, smoking, or inhaling purposes, and processed product made from cannabis seeds containing not more than 10 milligrams contain. It is not that you can use processed hemp fiber of 0.1% or less. It says you may not get a permit for processed hemp fiber containing 0.1% or less, etc. That's 7 of the Medicines Act. It is a criminal offence for a person to acquire, use, possess, manufacture, or supply cannabis without a permit issued by the Director General, which permit may only be issued in order to provide a medical practitioner the patient or for the purposes of education, analysis, or research. And so, my Lord, it is the reference to cannabis in the Drugs Act, its inclusion in Part 3 of Schedule 2 of the Drugs of the contend to be inconsistent with the Constitution and ought to be struck out. If I could deal briefly with the question of onus. With the issue in matters of this nature by dividing the substantive stage of human rights litigation into the 2 further substages of interpretation and limitation. The approach of the court to onus in respect to the stages is set out says this: the task of determining whether the provisions of an act are invalid because they are inconsistent with the guaranteed rights here under discussion of the guaranteed right. If so, a further inquiry as to whether such infringement is justified under the limitation clause. The task of interpreting the fundamental rights rests to prove the particular right in question. But concerning the second stage, it is for the legislature or the party relying on the legislation, the defendants in this case, my Lord, to establish was not justified. So put simply, my Lord, once the plaintiffs can establish a violation of their rights, then the onus shifts we will say, my Lord, it will be best dealt with in closing, but I'll or at least some of the rights which are contended to be violated are already prima facie established because of the common cause facts on the pleadings. The fact that they were found in or some of the rights are concerned, my Lord, we say those facts are common cause, and that prima facie establishes the violation of those rights, and therefore the onus shifts to the defendants. reasonable and justifiable in an open and democratic society based on human dignity, equality and freedom, taking into account all relevant factors, including the right, nature and extent of the limitation, the relation between the limitations and its purpose, and less restrictive means to achieve that purpose. The defendants, my lord, opposed the relief sought on the following broad grounds, as are apparent from the plea. They say that it's a dependence-producing substance, decision of Prince versus President of the Cape Law Society of 2002, and the argument is that we're dealing with matters which are much wider challenge than that which was dealt with in the Prince matter.
Yes.
They say that the third plaintiff's beliefs of the therapeutic effect of cannabis is not supported to counter the strict regulatory controls imposed by statute. They say that cannabis has adverse effects and is harmful to the health and social and psychological well-being of members of the public. Cannabis. And that these effects are wide-ranging and its use is linked to addiction, cognitive impairment, motor skills deficiency, respiratory, cardiovascular and mental problems, amongst other asserted by them is far outweighed by the risks arising from the use and possession thereof. They say that the use and possession of cannabis entails society and the economy generally. I touched on this yesterday, my lord, and your lordship cautioned me not to deal with the merits in the strikeout application. Why we say that's relevant to this case, my lord, is because it's pleaded by the defendant. The defendants say that the use of cannabis entails significant costs my lord, a comparison of the effects of criminalization on the economy versus effects of decriminalization on the economy. This within South Africa and abroad. They say that these factors demonstrate the rationality of the limitations that the Act imposes on the possession and use of cannabis. And they say attention, Lord, they say it is justifiable because there are several other open and democratic societies which prohibit the use and possession of cannabis. They say the prohibition is achieved that the provisions apply generally to all users and possessors regardless of the reason for such possession or use. They say it applies equally to all possessors and users without any undue discrimination or unfair disadvantage. Use and possession of cannabis, and that the purpose of the prohibition is to combat drug trafficking and the illicit trafficking of cannabis. They say that the prohibition is rationally less restrictive means to achieve the purpose of the prohibition, as, so they say, my lord, it would be practically difficult. That's in the plea, as it would be practically difficult, and the ability of law enforcement agents to enforce the provisions of the Act would be impaired. And my lord, the eighth raised. Now, the bulk of the evidence which is to be led in the trial, my Lord, is comprised of expert evidence. The plaintiffs have delivered expert summaries in respect of the evidence to be led by 7 expert witnesses. This morning have just delivered an 8th expert summary, and the 8th defendant has delivered 3. The defendant both real and imagined, my Lord, in our submission. But lest there be any doubt, my Lord, we may that the use of cannabis is harmless, or that there are no harms which arise as a consequence of its use. In some instances, whether the alleged harms are in fact caused by the use of cannabis, and there will be much debate, I anticipate, my Lord, as to that there is a statistical correlation between cannabis use and certain harms. The debate, though, is whether the extent of that correlation is sufficient. They will also differ, my Lord, on where there is agreement in regard to those harms which are alleged to be caused. However, completely hypothetical example and not based on any particular proposition contained in the papers or in the evidence. The use of cannabis is statistically linked to the onset of schizophrenia. There may be agreement between the experts in that regard. Correlation and indeed cause. Because, my Lord, your Lordship will no doubt appreciate that if there is strong evidence to suggest that cannabis causes schizophrenia in 9 out of 10, huge problem. There is strong evidence to suggest that it causes schizophrenia in 1 in 5 million people. That might be a different argument, my Lord, because then you're into the realm of, does that make it rational to diabetes, alcohol, and that link to the harms associated with alcohol. So the extent of the harm in that respect, my Lord, is something which must be weighed up. At the time of its initial criminalization. And where there is agreement on the extent of the harm suffered, the overbroad blunt force of an all-encompassing criminal prohibition. So, whilst we accept, my Lord, that there are harms associated with the use, justify a criminal prohibition of the cause of such harm. If it did, then other vices such as cigarettes, alcohol, sugar, caffeine, pornography, to hold otherwise, my Lord, would ignore the obvious fact that there are also harms which are associated with the criminalization of cannabis. The effect of sentenced to jail for something which, although contentious, is seen by many as a relatively harmless vice compared to other things which are legal. associated with the use of cannabis. We say, my lord, that by and large they have ignored the harms associated with the criminalization of cannabis. We say they have ignored my lord, the fact that punishing cannabis users with prison sentences for something which is on the evidence which will be proffered by the plaintiff, to mere government regulation, such as alcohol or cigarettes. It is telling, my lord, in our submission that the very first section under the heading The Republic of South Africa, founding provisions, states that the Republic on achievement of equality and the advancement of human rights and freedoms. These values, my lord, and particularly the reference to freedoms, we will submit, endow every person with the right to make personal autonomy protected is central to individual identity, and one is entitled to make decisions about these concerns without undue interference from the state. Of the Constitution, my lord, and we refer to the Teddy Bear Clinic judgment of the Constitutional Court at paragraph 64, where it was held that the right and absolutely divided along sharp, bright lines. Rather, there are levels of interconnectedness that must be acknowledged in any constitutional analysis. In fact, I'll be no more than 5 minutes, my lord.
All right, you may continue.
Thus, my lord, in the multitude of allegations and denials of contentions and explanations is whether, 1, those harms which are found to be causally connected to the use of cannabis are outweighed by the whether the harms associated with cannabis use are outweighed by the harms Three, whether the harms associated with cannabis use are so severe and far-reaching so as to justify its blanket criminalization, whether travel to treat cannabis users differently to users of substances which are equally, if not more harmful, which are not criminalized. And your lordship, in our and that their continued existence in their present form constitutes an unreasonable violation of the plaintiff's rights. Thank you. My lord, if I could distribute them to my learned friends and hand a copy up to your lordship.
Thank you. Thanks, Maurice. Thank you. The court adjourns until 2 o'clock. 2 o'clock.